An OWI third offense, a treatment court opportunity hanging in the balance, and a judge who is clearly frustrated by the delays. Today's Courtroom takes us through a case where one decision could change a man's future, a contractor dispute with thousands of dollars at stake, and a traffic ticket that turns into a lesson about trust and accountability. Stay with us, because by the end of this hearing, you'll be asking yourself one question: how much trouble can one bad decision really cause?
Okay. Sure, your name?
Peter Lockerford.
All right, go ahead. I'm sorry.
Gave us this opportunity to return because I tried to get a deviation report to Gary Bresnan. I had the wrong email. Eventually I did, thank you, as a result of the adjournment, get it to him. And he responded that he could get in a drug treatment court if we could get him in, and has to plead to the third. My client does not want to do it. He wants to waive the exam, and we'll file out. Just to let you know, my client had to take a blood test because he said he was diabetic. So I think that we have some technical defenses that would probably be better off in the evidentiary. And it's been 20 years since he had his.
So they wouldn't give you the,
Because he has an automatic rule if you have more.
he has what?
Well, I guess it's his policy if you have 4.
Oh, he had 4,
It's 4.
but they were a long time ago, weren't they?
No, you remember well. The last one was 20 years ago.
Yeah. Well, I mean, the idea is to get people some help. I'm sorry that he wouldn't do that. I'd have loved to have had him. I'll go ahead and take the waiver. Calling the,
He just said whatever I think is best.
calling the prosecutor, will you, John?
I was going by my client, what he wanted.
Yeah. So that's what you want to do, Mr. Lash?
Would the program be under you?
Not if there's a waiver.
No, if he entered the treatment court.
If he was doing it here, but they're not offering him that, right?
Yes, they did. In my opinion, they did.
I thought you said they didn't.
No, they offered him if he pled though.
Well, you said plead to OWI 3. I can't take a plea to OWI 3
I'm pretty sure that's fair. And then I could get him in the treatment.
in Detroit.
Yeah.
Yeah. So I'm just disappointed that they're not gonna do it here, but that's neither here nor there.
Well, up to remain.
So, all right, let me just get the prosecutor in
You're the
here.
state prosecutor, right?
Yeah,
She's not on.
Ms. Osmaro, right?
Right.
Just give me 1 second. All right, so sir, in the meantime, your lawyer is telling me that you wish to waive your right to an exam. Is that true? If you waive your right to an exam, you're waiving the requirement that they prove that the crime was committed and that you were the one who probably committed the crime of OWI 3, and you'll automatically be bound over for further proceedings to the circuit court. Do you understand that? Mrs. Morrow, your name?
Good morning, Your Honor. Nathaniel Asmer on behalf of the people, BAA Corinth.
Good morning. Listen, you did a no objection, a waiver form last time. I'm gonna need you to do one today. You don't have any objection to the waiver, correct? Can you write that up and send it in, please, real quick? So, sir, you understand everything that's going on here. You understand you're charged with a felony. If you waive your right to an exam, I'm sending you to Detroit for further proceedings. Anybody force you to give up your right to a preliminary exam? All right, counsel, can you write that up for me, please? Oh.
You would plead to a third here.
He can't plead to a third.
It downtown. Then if I found the.
Your Honor, we did this in Westland about 2 weeks ago. When I spoke to Gary Bresnahan, he's the APA who deals with all of our OWI thirds.
Right.
I did mention last time he has a kind of a list of things that he looks for when giving offers for OWI thirds. One of them being it has to be a true third, because this was his fourth, he did automatically deny it. But he also did mention, and again, we did this on a case in Westland, he pleads to an OWI third in district court, but he gets sentenced in circuit court, and then that's if the court allows him to come back and do some.
Just let him plead in circuit. Why would you not have him plead in circuit? I mean,
This exchange highlights something many people don't realize about the legal system. Judges can support rehabilitation, but they can't simply ignore jurisdictional limits. The court is dealing with an OWI third, a felony carrying serious consequences, and while treatment court options exist, they have to be handled through the proper channels. You can hear the judge's disappointment. He isn't just talking about paperwork, he's talking about a missed opportunity to get someone help before their situation gets worse. And notice the recurring theme here: timing matters. Had the parties reached an agreement earlier, this case may have taken a very different path. What do you think? Should courts prioritize treatment programs whenever possible, or should repeat offenders face the full weight of the law?
It makes no sense to me. If he's gonna, if,
Come back for Supreme Court, but that's.
well, they can take it back. If they want to reduce it there, you can tell the judge, whoever it is, will be happy to entertain it, as long as I approve of the terms and conditions.
Thank
Okay, I'll be happy to take it. But I'm gonna approve of the terms and conditions if there's a plea. So I don't want a circuit judge saying I gotta give 120 days, or, because I've gone over this on and on ad nauseum with the prosecutor's office. They want to say if they're, and I'm thinking that they're coming around. But I'm not gonna take a plea if it says judge has to give a year if they're convicted of a crime, which would include expired license, improper plate, and silly things like fishing without a license. I'm not doing that. So if they wanna conditionally send it back for my approval, I don't have a problem with that. Okay?
I understand, Your Honor, and the only reason we have that done as an OWI third in a different district court, Westland, was so that that offer could stick with APA Gary Bresnahan, opposed to going down to our general trials where another prosecutor will be the one to make that decision, so.
Well, if they pleaded to OWI 3 down there or here, I don't have any jurisdiction anymore. Right? How can I handle felony down there? I'm not a regional treatment court. No, I don't, I'm serious. There's regional treatment court in Taylor. I can't do that here. If it's pleading to an OWI 3, that's beyond our jurisdiction. If he's pleading to an OWI 2, that's within the framework of our jurisdiction.
I understand, Your Honor.
So, but I'm saying if they decide to plead to impaired 2 or OWI 2, and they want to remand, and I approve of the terms and conditions of the sentence agreement, I don't have a problem taking it back. But I'm not taking it back if I don't approve of the terms and conditions. So they can figure out how they want to do it down there. Do you understand everything that's going on? You have a charge of operating while intoxicated third, which is a 5-year felony. Our jurisdiction only goes up to OWI 2. I could take the plea, have you go downtown, get sentenced there, but it makes no sense to me here. None. Zero. Zip. Go down, let your lawyer work it out with the prosecutor. They've got a treatment court down there. This just took too long, you guys, really. I mean, so if you guys want to, but I want to be clear, I'm not taking back a case on remand unless I agree to the terms and conditions of probation, however they want to do that. Okay? All right. So you understand that you're going to be bound over for further proceedings to the circuit court.
Yeah.
And you understand that's a 5-year felony. And you understand you're waiving the requirement that they show that the crime was committed and that you were the one who probably committed the crime. Anybody forced you to give up your right to a preliminary exam? All right, I'll accept the waiver. PR bond is continued. AOI date will be January 27th. I still need you to put a form in here saying no. You don't have any objection to waiver, right?
No,
Pardon?
no, Your Honor.
Okay, good enough. That's fine.
Would you like me to go right?
Nah, don't worry about it. As long as you state it on the record. Thank you.
Thank you for your patience. and-
No problem.
Thank you.
Good luck. Have a good day. Good luck to you, sir. I hope this works out. Gustavo Cesar Velazquez, 25B149, 56R. Come on up here, sir. Your name?
Gustavo Velasquez,
How you doing?
pretty good.
You're doing the right thing coming in. Thank you. You're one of the guys that actually takes me up on this. You need more time to pay?
Yeah,
How long?
just one more month and then I'll be able to come in and knock it out.
Time to pay extended until February the 15th of 26. You did the right thing coming in. February 16th, okay? Good luck.
Thank you. Have a good.
You too. Miller. All right. Today is the date scheduled for a small claims hearing. Did you get this work done by somebody else?
No. Just you.
Today is the date scheduled for a small claims hearing. Each of you have the right to have the case removed to the general civil division. This is small claims. If you proceed in the small claims division, you're giving up rights. Plaintiff, you're giving up the right to seek in excess of $7,000. Both parties are giving up the right to appeal my decision, to hire a lawyer, and demand a trial by jury. You don't have to give up those rights. If you want to preserve any one or more of those rights, just tell me. I will remove the case to the general civil division, in which case you can appeal my decision if you don't like it. You can hire a lawyer if you want to. You can demand a trial by jury, and to the extent that plaintiff might be entitled to it, you can seek in excess of $7,000. Do you understand everything I just said, Mr. Malafi?
Yes, Your Honor.
Mr. Medina Cartagena?
Yes.
Do you wish to give up those rights and proceed here, or you wish to have the case removed? Mr. Malafi?
Like to continue.
You waive those rights?
Yes.
Mr. Medina Cartagena? Yes, what?
Yes, I would like to continue.
You waive those rights?
Yes.
John. 30 seconds or so. Raise your right hands, gentlemen. Either one of you have a witness? Anybody? Yep. No? No? Raise your right hands. You solemnly swear to affirm the testimony you'll give in these proceedings will be the whole true self you got.
So,
Okay. I don't understand. So it says defendant was hired contracted to renovate 2 bathrooms, raise existing vanity and paint it white for both bathrooms. He was paid through Zelle $8,000 and has since abandoned the project. I sent a demand letter wanting to resolve this matter out of court. However, the defendant has continued to ignore my attempts to resolve the issue. So did you paid him $8,000?
yes, I did.
You agreed that he paid you $8,000.
Yes, sir.
Was the contract, how much was the contract for? For him to perform this work? Do you have a written contract, gentlemen?
So we have, something that is signed for me to sign.
Did you sign it?
Yes, I did.
Hand it up. Now, what does that say? Sir, how much is the contract price?
So it was, so we were trying to do more work, so we're doing the 2 bathrooms and later on we're to do the basement. So we agreed on $8,000 to do both bathrooms.
Wait a minute. I don't know what this means. He's got basement, bathroom.
Sorry, Your Honor.
Hang on. Let me just talk. Summer project 2026, 1,800. Is it right that that's not included in this portion? Master bathroom room, 5,000. Guest or kids bathroom, 1,800. So was the contract for 6,800?
Plus material. I bought the material.
Why would you guys sign something on contract to perform work that you're not even gonna start until this summer? Right? Gentlemen, here's what I need you to do. How much do you think you completed the work? Yes or no?
Okay, I need to speak something that he gave me. That's not the invoice, correct? And he did not sign. So the invoice is actually the one I gave him last, which was $6,800.
Okay.
And that I have all the payments through the invoice from this invoice, not from that one. And that sign and that signature came from him after, not from the system. So the actual, it was a master bathroom and the kids' bathroom.
Right. I mean, it's pretty clear that that's what you guys
What
were.
pictures of the master bathroom finished? The
Hang
only
on,
thing I didn't put
hang
was
on,
the shower door.
hang on. Hang on. It's pretty clear that's what you guys were doing. 5,000. You got 5,000.
For the master bathroom,
I know. And 1,800 on the kids' bathroom, right?
yeah.
Okay. He gave you 8,000. Let me see your invoice. Just on a phone?
This small claims dispute quickly turns into a courtroom puzzle. One side says the job wasn't finished. The other says the work was substantially completed and that the numbers don't add up. Contracts, invoices, digital payments, and missing estimates. This is exactly why documentation matters. The judge isn't deciding who's right based on emotion. He's asking the question every court asks: can you prove it? Pictures alone don't establish damages. If a contractor leaves a project unfinished, the court needs evidence showing what it will cost to make things right. That's why an independent estimate becomes so important. Have you ever hired someone for home renovations? If so, you already know, nothing becomes expensive faster than a project that starts with a handshake and ends with a courtroom appearance.
Yeah, I have everything digital. Same thing with the receipts of the Home Depot, everything I purchased. Because he gave me 2,000 at the beginning was for material. So the 8,000 was 6,800 plus the 2,000.
He only gave you 8,000 though.
Yeah, but the 2,000 was for the material. I have all the receipts that was sent to his house.
I know, so are you saying he's light by $800?
That's what the system says here.
You wanna have all the money that I sent to him?
Wait a minute.
Yeah.
But you agree that you sent him 8,000, right?
Right. Yes.
And he's saying that you owed 6,800. Let me see. You guys, okay, good enough. So $8,000 defendant or plaintiff sent defendant. Defendant says he's entitled to 8,800. Right? So 800 more, right? You completed the work, right? You completed the master bath, you're telling me, in the guest room, right?
No, the guest bathroom was never,
How much work do you think you did?
we never started the guest bathroom because we came into this situation.
All right, did he complete the master bath?
He did not.
Did you get an estimate as to how much it would take to complete the master bath?
It was word of mouth. He said probably about a week he'll be able to be done.
Wait, slow down. Keep your voice up. I'm asking if you got an estimate from somebody else.
No, I haven't.
Well, how are you going to prove a case here? I don't know how much work he did toward the master bathroom.
I have pictures.
I know, but yeah, listen, you show me pictures, that's fine. I'm not going to sit here and say it would take another 2,200 or 1,400 or 3,900 to complete the master bathroom. You're going to have the master bathroom completed, right? Or not?
Yes, I'll have it done. Right now, it's not operable.
Right now, it's not
Yes,
one?
it's not operable. I've never used it, but since he did the work, I cannot.
Well, that's what, but here's what I'm trying to tell you nicely. I'm not saying you did or didn't complete it, Mr. Medina, Cartagena. I'm not saying you did or didn't. I am saying that you need to have somebody else come in. Because you agree that you didn't complete the master bedroom, right?
I completed the shower, which.
I didn't ask you that. I did not ask you that.
Your Honor, we agreed for the shower to be done, not the full bathroom. He knows that. He's giving you a wrong invoice.
Oh, wait a minute. Okay, let me see what you got. Is there a way that we can get this down to you, Jennifer, where you can copy this? I don't want to be looking at
If he can email him from his phone, I can
Go down
print
to
it for
the
you.
civil department and she'll tell you how to email it. She can print me out a copy.
Absolutely.
And if you got anything else, email it to her. So you guys go down to the civil department and I'll recopy this. My inclination is, though, if you don't think it was done, completed like he does, but I can tell you this, Mr. Medina, this invoice, the old one, and I'm not saying it's part of the new invoice that you're going to go down and print off or email the civil department. It does say install new vanity double sink, add 2 water supply, install shower door, install 2 lights in shower, change exhaust fan and mirror update. Maybe the new one doesn't have it. Go down the hall if you would, please. Email it to her and you guys come back, okay? I think I'm gonna end up telling you, we need to adjourn this so you can get another contractor out to give you an estimate as to how much, if he didn't complete it, that it would take to complete it, right?
Yes.
Okay, so go down and do that. Either way, come on back up here, okay? Young, Michael Ramon Young, 25T717307. Carlos Medina Cartagena, 2504565. Everybody's name.
Carlos Medina, Catherine.
Michael Moati.
Do you guys want to go and try and talk, or do you want me to adjourn this and you can get an estimate and bring everybody in, and the contractor can tell me what he didn't do, and you can tell me what he didn't do, Mr. Moathi, and you can tell me whatever you want if it's true. You know, you completed the project, 90% completed the project, or do you two want to go out in the hallway and try to resolve this? It's up to you.
Your Honor, I've tried to do that.
Okay, well,
and
look. I'm gonna adjourn it. I'm gonna give you an opportunity. I want to keep these papers here. Jennifer, I don't know what I'm
Judge,
gonna.
I kept a copy for
Perfect.
for us to scan in.
So can I keep these or not?
Yes.
All right, I'm gonna keep these papers. Actually, I'm gonna put them on the back of the register just so I can
Okay.
have them next time. We're gonna adjourn this. How long do you think it'll take you to get a contractor out and to take a look, Mr. Malathi?
I think 14 days I'll be able to do that.
Well, let's give you more time than that. I mean, maybe you have more success getting contractors out than I do. Let's adjourn it a month, Jennifer.
Can I comment?
Yeah,
From the paperwork he just provided, he sent the court.
Yeah.
Paperwork.
Yeah.
One of the things I see there missing is that he pulled out the.
okay, we're not gonna go into this because there's no way I can resolve this today.
Yes. I just wanted to comment that.
You can comment on that next time. Let me just adjourn it a month.
Okay.
Plaintiff to get contractor bid, and we'll go from there. Can you give me a date in February?
Yes, Your
Jennifer?
Honor. We can do February 24th.
No, I don't need to go that far. We're
That
not
far?
going.
Okay, then 10th.
February 10th. And that'll be at what time?
I'm looking here. That would be at 10.
All right. And if you have pictures, you're going to give me an estimate as to how much you think you still had to complete. Okay, fair enough. And you're going to give me a breakdown, both of them, as to how much. Let me just double check something here. I mean, if you agree you didn't do the kid's bathroom at all, right? So he didn't.
You can get to start, so.
All right, we'll see you guys back on that day. Okay? Bring any witnesses you want, but I need that estimate from a contractor, and I want him to be present.
Yes.
He can be present on Zoom. I don't have a problem with that. If he's busy or she's busy, whoever it is. All right?
All right.
Thank you both, gentlemen. We'll see you in 3 weeks or so. Good luck. American Express versus Hageman will be next. Your name, ma'am?
Jennifer Ashby.
Where you been?
I was unaware of the warrant. I had some arrest.
Did you get your ticket?
I didn't get anything. I believe that.
Hang on a second. You got written for impeding traffic. The officer handed you the ticket.
No, I was not driving my vehicle. I believe it was my roommate that was driving the vehicle, upon the ticket. And, she lives with me, so I didn't receive any mail, and I was pulled over and they said there was a warrant for my arrest. So I'm here today.
This wasn't you driving?
No.
Well, I can't, listen, here's what I can do. Can you post $237?
No, I was coming here to take care of trying to make a payment, man.
Well, why would you make a payment? Well, listen to me. This is a courtroom right now, okay? It's a courtroom. Why in the world would you come in here and ask me to give you a payment plan if you weren't the one driving?
This may be one of the most surprising moments of the hearing. Jennifer insists she wasn't driving, yet she arrived prepared to make a payment on the ticket. The judge immediately spots the contradiction and delivers a blunt reality check. If you weren't the driver, why would you accept responsibility? There's also a bigger issue here. Someone allegedly used her name during a traffic stop. If that's true, this case isn't just about impeding traffic anymore. It could involve providing false information to law enforcement. And then comes the judge's unforgettable line about friendship. Who needs enemies if you've got friends like that? So, let's hear from you in the comments. if a friend got you into legal trouble, would you forgive them, or would that friendship be over immediately?
Did you hear what I said?
I don't want the warning. For my rights.
Hang on. Were you driving or not driving?
I was not driving.
Why would you come in here and ask for a payment plan if you weren't driving?
That's what the officer said to do,
The officer said to come in and ask for a
to
payment?
take care of it.
Slow down. What officer?
I was pulled over yesterday, in a car and they ran my name.
Did you tell him or her that you weren't driving on this date?
Yes, and they said to come to court, open court to take care of it, and that's what they did.
No, I thought you just said the officer told you to come in here and make a payment.
To take care of it. Yes, that's what I'm here to do.
Ma'am, I need you to post a bond. I'll be glad to entertain a motion to set aside default, but the rules are the rules. And you have to file a motion. And it doesn't have to be lengthy. They have them down there, and post a bond equivalent to the amount of the judgment, which right now is $237. Are you still maintaining you weren't the driver?
Yes,
You have a credit card you can put this on?
no, I brought $40 to make a payment. I don't have it.
Why would you listen to me? We don't live in Russia. I know it's just a civil infraction, but you don't come in here and start paying tickets if you weren't the driver. Now, your friend's going to have a problem because she's going to get charged with false information to an officer. You understand what I'm saying? You post $237 within 7 days, and you fill out a motion. I think it's seven. You post 230. Go borrow some money. Come on back. File a motion to set aside the default judgment. Okay? You can go right down the hall. I'm not taking your $40 now. Save that for towards your 237. Okay? You shouldn't be coming in here. You don't want this up. No, it's not. Come on. I hope you guys people have more confidence in the judicial system than that, where they think if somebody uses their name and writes their friend a ticket, and the friend doesn't split, I hope you're still friends with this girl?
Well,
Are you still friends with this girl?
friends with me.
Well, how can you be friends with somebody that just got you in trouble by giving false information to a police officer? I'm just telling you, I'm not going to give you advice on who to choose and not to choose as friends, but somebody did that to me. Get out of my house and evict if you have to, and you're done with me. What kind of friend is that? Who needs enemies if you got friends like that? 237, post it within 7 days. Come in, file a motion. Okay, good luck to you. I wish you well. Listen, we're going to treat you fairly, but you have to write in the motion that this wasn't you, and you just found out on January 12th when the officer pulled you over, okay? Make sure you come back with that money.
Today's courtroom session showcased 3 very different legal lessons. First, an OWI third defendant learned that rehabilitation opportunities exist, but procedure and timing can make all the difference. Second, a contractor dispute reminded everyone that contracts and estimates are often the difference between winning and losing in small claims court. And finally, a traffic case became an unexpected lesson in personal responsibility and the risks of trusting the wrong people. The common thread through all of these cases is accountability. Whether it's a felony charge, unfinished construction work, or a disputed traffic ticket, the court ultimately relies on facts, evidence, and credibility. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.